the State Interest and Governance Authority Act 2019, Act 990. And in this, when we were passing this act, a provision was made for the position of the minister to be responsible for SIGA, and that is SIGA, State Interest and Governance Authority, which was created by this act. And Honorable Chair, the act, as I show a copy to you, mentions the minister responsible for oversighting SIGA, mentions it 18 times in this act, which was passed by this House. And the interpretation portion clarifies the role, the meaning of the minister in respect of this act. The 18 times mentioned gives clear and distinct of something I would call job description or role of the minister to oversight the administration, effective administration of this act as passed by this House. SIGA has been working, it's been in existence since the passing of this act and making sure that the provisions. So, SIGA has about 86 declared or specified public enterprises, and the role of this ministry is to oversight them. Some government has a minimum of 10%, some 100%, and some 20% and so on. But government interest, like you are saying, government interest in these public enterprises are what this ministry is created to oversight.
So, would you say that your definition of a public interest, a public corporation or public corporation, is that which has been defined by the Act?
Yes.
Yes.
Chairman, yes.
Well, so this is not your definition, but that which is in the Act?
Yes, Chairman.
Very well.
So, in essence, the ministry's role would be to oversee public enterprises and to also oversee the interests of the state in other enterprises that may not necessarily be, corporations, state-owned corporations, and etc. Wherever, in any other enterprise in which the state has interest, then the ministry will be responsible, or the minister will be responsible for overseeing the management of that interest.
Exactly so, Chairman.
For the second part of the question.
The state of the public enterprises today, as we can all identify with, include high losses. The high losses of these enterprises, indebtedness, and low productivity, low efficiency, weak governance structures also exist to ensure that they operate profitably, and also there is fragmented coordination of the government interest to oversight these enterprises. When it comes to the profitability, efficiency issues, this we all know has been a drain on government resources because government invested for returns, but that is not what is happening. That is the state now, and that presents problem to be solved. And that is what His Excellency, the President, is trying to focus attention on, to make sure that this situation is addressed. Thank you, Chairman.
Chairman, with your indulgence, we have, as I've indicated, Honorable Cudjoe is one of us. My objection, I think, is fundamental. I would wish that you relate to the presidency just to give us a formal official correspondence to enable us proceed, even if it takes midnight with the correspondence from the presidency will do. But as we proceed, there is no Ministry for Public Enterprises, and our hands are tied because we should be assessing him based on the role he's going to play at that particular sector. So, Chairman, I'm making an application to you, and your ruling, the Constitution supersedes an EI. I have said that I have no difficulty with the President exercising his mandate under Article 78, but we are vetting him for what purposes? So, Chairman, if we can, we allow us to do consultation momentarily for 5-10 minutes, but I think that you and the leadership must be reaching out to the President to provide further and better particulars for us to proceed. I'll plead with you, Chairman. Allow us 5 minutes, then I do a consultation, and then we proceed. But to Honorable Cudjoe, bear with us. We are following fidelity and respect to the law. Chairman has done
instructions. That's not the challenge. Obviously, we are discussing this. That's if we have come to a conclusion.
Mr. Chair, if I may have the floor. Mr. Chair, if we give due regard to Article 78(1) with respect, quote, ministers of state shall be appointed by the President with the prior approval of Parliament from among members of Parliament or persons qualified to be elected as members of Parliament, except that the majority of ministers of state shall be appointed from among members of Parliament. So, Mr. Speaker, Mr. Chair, fundamentally, the nomination by the President, the effect is that the person becomes a Minister of State and not appointed to a particular ministry. I have said, and I will repeat, that the fundamental issue of clarity raised by my respected colleague is well grounded. But if you look at how it is situated, it is only in form. In substance, a Minister of State has been nominated for vetting here. So the ministry has a tie to it that he is saying that, look, he sees that there is some omission. To what extent does that stop us from proceeding? If the intention is to get clarity, then my view is that as Parliament, we can proceed. What we are doing now is not a finality. In fact, after voting, we will not even take a vote now, or that we are not the plenary. I therefore hold the humble view that the earlier position by Mr. Chair that we can proceed whilst immediate steps are taken for clarity on this matter would not in any event have any serious effect on our work. It would rather help us proceed as time is of the essence and as the supposed defect is not so fundamental. So I would humbly plead with the Honorable Minority Leader that it wouldn't help to proceed whilst the very clarity he seeks to get is pursued by the chair. After all, he is part of the leadership of this committee. So the communication will be transmitted to the appointing authority for clarity. Thank you, Mr. Chair.
So, Chairman, my application is still before you. It's not my intention that we take sides in this national exercise, but momentarily for Honorable Cudjoe, our side will just sit and observe whilst we wait for clarity and better particulars from the presidency. We do not intend to take part in further proceedings until we receive satisfactory explanation from the office of the president. So that will be our attitude to his vetting. Thank you, Chair.
Very well. But there's this point I must make clear. I think there are certain matters which require decision by the committee. And so if we have raised issues like this, you raise it at our pre-sitting meeting or pre-sitting, we'll discuss them and take a decision. I think we should not continue to jump matters after we have brought in a nominee and sworn him for consideration. The second one is that I think it's totally inappropriate for me, sitting here as a committee chairman, to take a matter arising out of here to the presidency without going through Mr. Speaker. We're a committee of the House. The matter is brought before us at the committee. We report to the House, and in particular instance through Mr. Speaker. I don't think I should be able to go behind Mr. Speaker to speak to the presidency in matters like this. So let's proceed with what we can. It's noted that an objection or a question is raised as to a ministry not created, so to speak. It will be contained in our report that this matter was brought to our attention as a committee, and we draw the House's attention to it. But please, let's proceed. Yes, Honorable Bob.
Mr. Speaker, Mr. Chairman, I think you've made a very good point, but I suggest that we've been sitting as a committee and we've worked closely together up to this point. If we could give ourselves some 10 minutes off camera to discuss some of these issues that we've raised. Say again, we should proceed. If the chairman has ruled, fine. But I was thinking we should, because we've worked closely to this point, and this is not a matter that should break that cordiality. We should go off camera, sit and resolve this in 5 minutes. I don't think a phone call to seek clarity will spoil anything. Thank you.
Yes.
Mr. Chairman, thank you very much. Mr. Chairman, I strongly support the suggestion by my respected colleague, Honorable Patrick Boama. 10 minutes, because we are here to work and we are willing to work. We have nothing personal against the nominee. It's just a fundamental legal issue our leader has raised. So let's not, as it were, affect the cordiality and congeniality with which we have worked thus far. So, Mr. Chairman, I don't think 10 minutes to go into conclave and seek further clarification from Mr. Speaker and His Excellency the President will hurt. Just 10 minutes, Mr. Speaker.
Do I have consensus on that?
Chairman, if you listened to me earlier, I requested for this. I said we should just have 10 minutes consultation. I only came in when that was kind of not respected. I did so. If you want to go back to the record, I couldn't have. That's when you even said that we should take a decision as a whole. I did. I said just 10 minutes consultation. I have nothing against the nominee, but we just want respect to the law.
I was asking whether we have a consensus on suspending and doing.
No, just 5 minutes consultation. I think so. 5 minutes.
Very well.
To the extent that we are making this call in good faith and we hope to maintain the good atmosphere, why not? To the extent that we mean well and we want to do so, why not?
We will discuss all that when. Yes, so the nominee will kindly excuse us. We will call you back, please. Thank you, Chairman.